All right, 1:30 now, and today we are diving into a pivotal legal debate. Should regular marijuana users be allowed to own guns? The Supreme Court is set to decide. Joining us is Defense Attorney Jeremy Rosenfeld to unpack the legal, constitutional, and societal implications of this case. Welcome back to the news desk, Mr. Rosenthal. Appreciate your time today.
Always, Jay. How are you?
I'm doing great, thank you. So, how does this case challenge or even align with the Second Amendment as interpreted in the recent SCOTUS challenge, or rulings, rather?
There's been a lot of action with regards to the Second Amendment in front of the Supreme Court. A lot of that is due to the Supreme Court breakdown, 6-3 conservative. A lot of gun rights advocates, a lot of groups are being aggressive and trying to take advantage of the Supreme Court in its current composition, hoping to get some good rulings. You never know how long, when the numbers are in your favor, you never know how long that's going to be for. So they've been quite bullish on those grounds. This regulation this is sort of your Hunter Biden rule, if you will. And one thing that we don't like in the law is we don't like a lot of subjectivity. We don't like a lot of mushy boundaries and lines. And when you start talking about addicts cannot use weapons or cannot buy weapons, you get a lot of uncertainty there. You get a lot of uncertainty because addicts aren't particularly good at self-diagnosing. They're not really good at recognizing that they're addicted to something. Are they committing a crime? Are they not committing a crime? You add an extra layer here in this case, which is use of marijuana, which is legal in some instances, depending on what state you live in, and it just gets even muddier. It's a ripe case for the court to consider.
Yeah, so how do courts typically reconcile, I guess, federal gun laws then with evolving state marijuana laws?
That's exactly the question. So marijuana is still a Schedule One narcotic, so it's still illegal. President Trump has sort of flirted with the idea of lowering that to I think a Schedule Three. That's not something that's necessarily done overnight. You have to have a lot of regulatory approval from the chain, and that's sort of started here. I believe it started in 2021, 2022, and it never came to Joe Biden's desk, which is I don't know that he would have proved it or not, but it never got there in time, and it's on Donald Trump's desk. He could make that change if he wanted, but still, so you have certain states that legalize it, and where the feds have kind of come down on that is they've said, listen, if you as a state have a robust regulatory and statutory scheme, we're not going to mess with your cannabis industry. You better police it on your own, but we're not going to necessarily mess with it. But yes, you sort of have a contradiction in laws. You have you have one jurisdiction that says it's perfectly legal. The federal government says it's not, and it's going to bar you from owning a firearm. So what gives, right? If you're doing something that's completely legal in your state, doing so can still cost you your Second Amendment rights. That's why those guys get paid the big bucks, even though their paychecks are currently frozen.
So let me ask you this, Jeremy. Is this case really about safety, or is it about preserving outdated federal control over marijuana policy through backdoor enforcement?
If anything, I think it's really more about firearms. And the reason why I say that is because the only constitutional amendment really getting kicked around here is the Second Amendment. And anytime you're dealing with a constitutional amendment, it's what lawyers and courts call a fundamental right. And you don't have a fundamental right to smoke marijuana. You don't have a fundamental right necessarily to drink alcohol or consume beef or anything like that. But you do have a fundamental right to possess a firearm. So it's whether or not your right to own a firearm is inhibited, and is it inhibited by a rule that just isn't workable? That's the question.
Could this decision open the door for broader gun rights among other groups currently restricted, like those with mental health issues or even past misdemeanors?
A great question, and this is some of the battle lines that I think we've seen over the past few years when it comes to Second Amendment type cases. We've had cases that have dealt with age limitations and age restrictions. We've had cases that have dealt with Not only that, but we've also had cases that have dealt with certain types of weapons. We've also had so we take all these other characteristics in conjunction with it, and that's sort of the moving boundary, if you will. A lot of domestic violence type situations. There was a very significant opinion came out last year that had to do with what happens if you have a domestic violence conviction. How does that impact your Second Amendment rights? So a lot of these, so we're bouncing a lot of different factors, a lot of different circumstances off the Second Amendment to see what it is. And in this instance, you're also talking about actual legislation, and it's made illegal by an act that's from the 1960s. So the question is whether that act is so broad that it's not constitutional. Is the language of it, is the phrasing of it so broad and unworkable that it becomes unconstitutional? Because again, what does it mean to be an addict? These were questions that we talked really about in the Hunter Biden case. Hunter Biden had used, I think, illegal drugs within a week and a half of him purchasing the firearm, and then he signs a form that says, "I am not an addict." And one of the problems when you're prosecuting somebody criminally is the intent to defraud or the intent to be dishonest. And not saying Hunter Biden was honest or dishonest there, but a lot of addicts will quit using some type of illegal drug on day one, and day two, they'll tell the whole world that they're clean and sober, and they mean it. So these things are a lot of times just really very messy and very unworkable. So it'll be interesting to see what the court comes back and does. My inkling is that they'll probably strike the provision, and that it will sort of clean it up and at least let people who smoke marijuana at least they won't have that worry when they're signing a form to purchase a firearm.
Do you think this case could influence future federal drug policy or gun legislation?
It certainly could. It's really hard, I think, to get that type of legislation all the way home. Congress right now, if you haven't noticed, has a hard time agreeing on anything. So it's really difficult, especially with it's hard enough when we're talking about just making the federal government go back to work and funding air traffic controllers and courts and mental health programs and infrastructure programs. It's hard enough to get consensus on that. And firearm legislation is certainly even more difficult. That said, if this provision gets struck, you would think that probably some folks who want to see there be a little tighter nexus, they might phrase this a little differently. They might say, if you have used a Schedule I narcotic within 30 days of purchasing a firearm, then you are prohibited. That would be a little tighter than saying you're addicted to it, right?
Yeah. What would you like to see lawmakers do with this gray area?
Well, what courts like is clarity, and what courts like is sort of certainty, and that's why you're seeing this tension here, is because you're fighting over some of these really broad words and terms, and not only that, when you're talking about marijuana in particular, now you're talking about something that again is legal in, I don't know, half the country and illegal in the other half, and then you're even talking about perfectly legal activity, and having that bar you from a fundamental right, and that part can be kind of troubling. I think as lawyers, I think as courts, I think what the goal is to try to unsmudge the lens, if you will, with which we look at these things. Everybody likes clarity. That goes for probably the gun manufacturing industry. Companies, sporting goods stores that sell firearms, federal firearm carriers, people who possess weapons, even people who consume marijuana. Everybody's sort of entitled to that clarity to know whether or not what they're doing is legal or not legal. So I would hope that if the courts can't provide that clarity, that Congress hopefully could.
Hopefully they can. Jeremy, as a defense attorney, how would you advise clients who consume marijuana and also own firearms? What would be your recommendation for them? One or the other?
Well, in Texas, it's still illegal to possess marijuana. But I think that all you can do as a lawyer is tell people what they can and can't do and what the law is, and people are going to make their own choices, based on that. And so I would obviously tell folks that, look, the law says we can't do it this way currently. And if the Supreme Court comes back and says otherwise, then, I'll advise them of such there. Also, not only that, one of the problems that you have with court opinions is that they're exactly that. They're opinions. And and opinions, legal opinions are subject to different interpretations, and they're subject to changing. And so to advise a client, for instance, currently the current Supreme Court, and in Texas, I'll give you this much. Delta 8 is not the same thing, obviously, as Delta 9 with marijuana. I know your audience is very savvy with their THC knowledge and their marijuana savviness. But Delta 8 was debatable whether or not the Texas legislature had actually legalized it several years ago. And currently, there's an injunction by a court in Austin enjoining the state of Texas from enforcing Delta 8 as if it's Delta 9, right, as marijuana. So if a client comes and asks, Jeremy, can I smoke Delta 8? I don't really love advising them that there's a current injunction that can go away at any moment. And so the answer is, on paper, the state would tell you that it's illegal, but a court at the moment is not enforcing that. That's a real thin line. Whoever's going to do that's probably smoking Delta 8 and Delta 9 anyway. But all we can do is tell the client, sort of what we think of that law.
Jeremy, throw on your Supreme Court robe for just a moment and tell me, what do you think they're going to decide?
I think they're going to strike this provision, and I think they're going to do so because I think they're going to say it's too blurry, and the term addiction, and also being a marijuana user, that's active tense. That doesn't really fit. That doesn't really square very nicely when you're talking about a fundamental right in terms of possessing and utilization of a firearm. That's what I think they do. And I think I've been wrong a couple times over the last few decades, but not often.
Not often. Jeremy Rosenthal, always a pleasure to visit with you, sir. Good knowledge, my friend.
You got it. And by the way, Plano is right down the street from me, and I'll be looking for the monkeys at the Walmart.
Yeah, that's where they're at. So if you see one on the street, you may want to pick them up. So there you go, Jeremy. Thank you so much, sir.